So we would like to discuss the second part of uh, our lecture with respect to the concept of separation of powers. So just a quick recap of what we did last class. We did make the point that separation of powers viewed as a concept or doctrine is really important for securing democracy in a way which will safeguard the liberty of the citizen. And the basic idea is that too much power reposed in an individual or one institution is a recipe for arbitrariness and counterproductive to liberty. So, thinkers or scholars for many centuries have opined that it is necessary to split the functions of governance or what constitutes governance. And traditionally, governance is understood to encapsulate three main things: those who make law, those who implement the law or the policy, and those whose duty it is to interpret and enforce the law. So we have the legislature, we have the executive, we have the judiciary. And thinkers are of the view that it is not advisable to vest the power of legislation or the power of the executive or the power of law enforcement or judiciary in one institution or in one person. Otherwise, as we are told, absolute power corrupts absolutely, and the liberty of the individual will be the victim. We said that, yes, separation of powers was understood sometimes in a very rigid or strict sense, that each of the three arms of government, so to speak, should be in their own channel, should be in their own domain, and there should be no overlapping whatsoever. Now, that has been demonstrated, as we saw in our class, to be unworkable, and it will let the wheels of governance actually grind to a halt. There will be stalemate. And for that matter, a more flexible or modified understanding of separation of powers has evolved. And that entails what we usually call separation of powers with the checks and balances. That is to say that whilst powers, functions, and authority are delineated, it is also contemplated that there will be working cooperation, there will be interdependence between the various arms or domains of governance. Now, tonight, we would like to discuss separation of power in Ghana and also modern refinement of separation of power. Especially, I would like us to look at the US Supreme Court decision in the seizure case. We come to that after the historical introduction to separation of powers in Ghana. So as far as our country, Ghana, is concerned, the doctrine or the concept of separation of powers has gone through evolutionary trajectory since our independence. until present day. And I use the word evolution in the sense that when it comes to constitutional law, right? When it comes to constitutional law, just as we remember from the famous words or the dicta of SOA JSC into 4 versus Attorney General, that society is dynamic, society is in flux, and for that matter, our constitution is also dynamic. So our ideas concerning separation of power, for example, is still evolving. And just recently, what we are witnessing in our body politics, including the case we just discussed before starting today's class, the case between Honorable Afenyo Makin and the Honorable Speaker of Parliament and Attorney General. Now, the circumstances leading up to that case and after that case are still indicative that separation of powers, our understanding of it, are all still evolving. In fact, I read a piece in Daily Graphic today. I don't remember the name of the author. The paper is in my office. And I was basically trying to say that the case which went to Supreme Court and the decision of the Supreme Court are all trying to undermine the principal position of the Speaker of Parliament. And that is a threat to constitutional democracy. Of course, when I read it, I just thought that the person must probably be like a non-legal or non-constitutional person, student. And for that matter, he or she is at liberty to look at things from other perspective. That is fine. But that in itself should tell you that our understanding of some of these concepts are still evolving. So that is the point that we are trying to make. But this evolution has also been affected by, as you remember, the military intervention in our governance. So just as we are making progress, then the military will emerge and they will destroy the learning gains that we have made. So if we take our, for example, how we moved from 1966 to 1969 Constitution, we did not practice our parliamentary system of governance for even 3 years, and there was overthrow. So those are some of the challenges that we've had to grapple with as people. But before we proceed, a very landmark case which reflects our initial struggles with separation of powers is the case of Ray Akoto and 7 others. So Bafo Akoto and 7 others. If you remember, I asked you to read that case. I want to believe that you've read it. The case where the Asante chief linguist and other people who were with the National Liberation Movement and Martin who were actually arrested, and they were detained without trial, as it were, and a habeas corpus application was brought by their lawyer, J.B. Dankwa, and the Supreme Court actually took the view that if you look at the law under which they were arrested, the Preventive Detention Act, and if you look at the relevant provisions of the Constitution, which were actually invoked, they were of the view that the executive could not be challenged regarding the exercise of their powers under Preventive Detention Act. And if anything at all, it is the electorate who will have to make a political judgment. Because as you remember from our previous class, they said that the provisions in Article 13 of the 1960 Constitution were similar to the coronation oath made by the monarch of England. And for that matter, if the people are not happy, then when there is an opportunity for them to vote, then they will decide. But it's not for the court to actually determine whether that is actually necessary of the constitutional provision or not, as it were. So in a nutshell, they were saying that the Constitution, in their view, did not give them the power to strike down certain executive acts as being unconstitutional. And we all know what happened thereafter. Now, if you look at our current Constitution, it is a very important milestone in our search for constitutional democracy, and more importantly, for our present purpose, in our search for workable version of separation of powers. Now, if you look at the Constitution, you go to the preamble, okay? Take your Constitution and look at the preamble. This is what the preamble says, and I quote, in the name of the Almighty God, we the people of Ghana, in exercise of our natural inalienable right to establish a framework of government, which shall secure for ourselves and posterity the plans of liberty, equality, opportunity, and prosperity, in a spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability. The principle that all powers of government spring from the sovereign will of the people. The principle of universal adult suffrage. The rule of law. Protection of fundamental human rights. Yes, I'm teaching. Yeah, I'll call them. The protection and preservation of fundamental human rights and freedoms, unity and stability of our nation, do hereby adopt and give. Now, if you examine the preamble, no doubt, we are told that we want a government which is limited, because you cannot have accountability and probity if you don't have a government which is unlimited. You must have a limited government. And how do you get a limited government? You are going to get a limited government. What it means is that you need separation of powers, because separation of powers would actually say that, yes, the legislature, you can only have so much power of this, the power of lawmaking within these parameters. The judiciary, you can only have this power of judicial review within these parameters. Executive, you can have this power of executive authority within these parameters. So clearly, if we look at our Constitution, we have the conviction that we need a framework of government where government is limited, where we have probity and accountability, so as to safeguard fundamental human rights and freedom. And that is why the Constitution itself has delineated the functions and powers of the executive, the legislature, and the judicial branches. And the whole point is to create a framework intended to prevent any one branch from dominating the others, so to speak. And that is why, if you look at the current discourse or going on in the various media space, you notice that when people are referring to the legislature, they'll say that it is an equal branch of government. And no, they'll say like co-equal branch, co-equal. That is to say that it is It enjoys equality with the other branches of government. It's not superior to any branch, neither is it inferior to any branch, so to speak. So if you look at the Constitution, it has some key provisions reflective of separation of powers. Article 58, as we know, vests executive authority in the president, outlining the scope of executive authority and the president's responsibilities in governance. So if you look at your Constitution, that is what it says, and you've read that a couple of times. So therefore, when it comes to executive authority, we have no doubt in our mind regarding where it is located. It's located in the president. Article 93 vests legislative power in parliament and gives parliament exclusive authority to make laws. And for that matter, the legislature is set up as a separate and independent entity within the governance framework. And that is why when you are discussing sources of law in Ghana, okay, in your legal system, even in constitutional law, the introduction, we mentioned it. If you look at Article 11, we have what we call subsidiary legislation, that is rules, regulations, subsidiary legislation under greater legislation. So called because Parliament, ordinarily speaking, is the body which is given the exclusive authority to make law. And I'm going to give you a typical example from the Constitution, which reinforces that point we are making. Now, how do we know that as a matter of constitutional reality, Parliament is the arm of government, branch of government, which has been given exclusive authority to make laws? Now, I refer you to Article 11 clause. Article 11 clause 7. Article 11 clause 7. Clause 7 A and C. Any order, rule, or regulation made by a person or authority under a power conferred by this Constitution or any other law shall be laid before Parliament, shall be published in the Gazette on the day it is laid before Parliament, and C, come into force at the expiration of 21 sitting days after being so laid, unless Parliament before expiration of 21 days annuls the order, and so on. Now, this provision is the evidence from the Constitution, which reinforces Article 93 that Parliament is the body which has been given the exclusive authority to make laws. And so if you look at Article 93 too, subject to provision of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. So if you read Article 93 clause 2 together with Article 11 clause 7 of the Constitution, then we can say that, yes, exclusive authority to make law is in Parliament. Let us illustrate that. Yes, other bodies, the Electoral Commission, for example, is given power to make rules or regulation by a constitutional instrument to govern the conduct of elections in Ghana. So the Electoral Commission has got that power to make rules to govern the elections in Ghana. However, where Electoral Commission has exercised its power to make rules or regulation by means of constitutional instruments to govern the conduct of elections in Ghana. Now, that constitutional instrument is still an order or regulation contemplated by Article 11, Clause 7. And for that matter, it will have to be laid before Parliament. Why should it be late? It should be late because the ultimate lawmaking power is vested in Parliament. And that is why, if for whatever reason, the Constitution has even given you some powers that you can, yes, because you want you to be independent, you can make certain rules. You make the rules, but you need to validate them by complying with Article 11, Clause 7. You lay it before Parliament. Parliament has a committee you call the Committee on Subsidiary Legislation. And when it is laid, Parliament can decide to annul it by two-thirds majority. But if Parliament decides not to annul it by two-thirds majority, then automatically, at the 21 sitting days, it will come into force. Yes, Mike Amano.
Yeah, my lord.
Yes.
Yes, the area.
Sorry, I live along the flight path.
Brings
What
to
the aeroplane
mind
flies,
the doctrine.
I lose it, so you have
My
to repeat
question is,
what you said.
my question, okay. My question is that how come laws that are made by judges are not also laid before Parliament for such processes to be?
Yeah, okay.
Because, like you just explained,
Okay.
when bodies that are established by the Constitution makes laws, they have to lay it before Parliament. But we know that judges also make laws through judicial presidents and all that. So how come when they make decisions that they want to repeat in instant cases, they don't actually lay their laws before Parliament, to
Right.
go through the same process that you just mentioned?
All right. Thank you, Mr. Manuel. Yes, so that's a very good question. Yes, the courts or judges, by their decisions, are also making law through the judicial precedent or stare decisis doctrine. However, it does not have to go through Article 11, Clause 7, because it is not example of delegated legislation. Judges cannot make law to override provisions of Act of Parliament, to override provisions of delegated legislation. What the courts do is to tell us the meaning, the import of laws made by Parliament or by delegated authorities, which Parliament has empowered. So that is it. So they don't make laws per se, but yes, they make law through their interpretation. Or probably if you want to do the common law, for example, when it comes to the law of contract, you notice that about 80 to 90% of the principles that you are learning in law of contract are actually case law, and they are not based on any statutory provision, apart from the Contract Act at 25, apart from the Electronic Transactions Act, and one or two others, Sale of Goods Act, the Auction Sales Law. You don't have much by way of legislation as far as contract is concerned. And the bulk of the rules are judge-made rules. Yeah, so you have a legitimate point, but the answer, in my view, I think is what I'm giving you, that they are not making law in the ways that laws are made within the meaning of Article 11, Clause 7, and within the meaning of Article 93, Clause 2 of the Constitution. Again, if we look at Article 125, judicial power is vested in the judiciary. And the Supreme Court is the highest authority in matters of constitutional interpretation. And it's also called like the policy court, as it were. And for that matter, where there's a dispute regarding the proper meaning or understanding of anything constitutional, the Supreme Court is the proper place to go and not any other place. as it were. Of course, we also have independent bodies set up within the constitutional architecture. So we have like the Commission on Administrative Justice, we have Human Rights Administrative Justice, we have the Electoral Commission, National Media Commission, National Commission on Civic Education. All these independent constitutional bodies play important role as far as checks and balances among branches of government are concerned. Yeah, so the provisions that we have mentioned, no doubt, they implicitly or impliedly establish a structure based on separation of powers. At the same time, they also allow for necessary interdependence among the branches. So there's an attempt to balance independence with the cooperation needed for effective governance. And that is very important. We'll be discussing a few cases, but we know the New Patriotic Party against Attorney General. For example, the case where the NPP as the opposition party at the time decided to actually go to court and challenge the celebration of the 31st December revolution using state resources. And in that case, the Chief Justice Archer, while emphasizing that the judiciary has the power to interpret and enforce the Constitution, also cautioned that it must avoid overstepping its mandate by encroaching on legislative or executive functions. So if you read the judgment, you notice that he warned against what we call the judicial officiousness and used the expression that the court should not behave like an octopus, stretching its 8 tentacles here and there to grab jurisdiction, which is not constitutionally meant for it. Of course, that case just similar to what we have, especially if you read the minority decision, Justice Tanko, and to some extent, Justice Ivory Johnson. You may want to reflect, yes, when it comes to matters within Parliament, should the courts assume jurisdiction? Should the court assume jurisdiction? Or you would like to get the situation, the argument which was made into form as the Attorney General by the Attorney General at the time, that what takes place in Parliament is like a closed book. Should that be the case? And if that were so, what would be the relevance of the constitutional provision which set up the doctrine of constitutional supremacy, and also Article 130, so Article 2 and Article 130, which also says that if you are alleging that anything has been done or failed to be done, and same is in contravention of the letter and spirit of the Constitution, you must go to the Supreme Court and seek interpretation or declaration to that effect. So how would that be relevant? So these are matters that we have to reflect on or think through as we go through. So we talk about the 31st December case. We also have the, what you call the Ghana Bar Association against the Attorney General. And that case had to do with the attempt by the Lawyers Association in Ghana, called the Ghana Bar Association, to challenge the appointment of Justice Isaac Aban as Chief Justice because they allege that he lacked moral integrity. Now, if you look at the Constitution, we appointed a justice, and for that matter, the Chief Justice General, that you must have a proven, integrity. And the Attorney General, that's Dr. Obeda Samoa at the time, argued that the judiciary had no jurisdiction, had over the appointment, because appointment of a Chief Justice, in their view, was a matter within the executive domain. And so they wanted to say that, yes, there is non-justiciability of certain executive actions. So if the president has nominated someone to be a Chief Justice, can you challenge it in court and say that the person does not meet the qualification criteria? Or because the person will be vetted by Parliament, we leave that to the decision of Parliament, as it were. Of course, we also have Judicial against the Attorney General again, how to call the fast track high court case, if you remember. Mr. Chikata, in relation to the work he did some time ago as a chair and as a CEO of the Ghana National Petroleum Commission and other things, was actually arrested and was to be tried for causing financial loss to the state. He was arraigned before a high court, which has got a new division called the Fast Track High Court. It was so called because that was the time that digitization had actually started. So in those courts, we have like a automation, a recording system and everything. And that is why it was called like the Fast Track High Court. So instead of being put before the ordinary or general jurisdiction, as it were, he was being tried there. And his lawyer at the time went to Supreme Court to challenge the constitutionality of the Fast Track High Court. So that is what the case was about. Now, the ordinary panel of the Supreme Court agreed with the plaintiff's case, but meaning that the Fast Track High Court, which have been established and all that they had done, were to be null and void because they were seen as being unconstitutional. But the panel was expanded and the review jurisdiction of the Supreme Court was invoked in respect of the decision by the ordinary panel. And the expanded panel reversed the initial decision and said that if you look at the Constitution, if you look at the powers of the Chief Justice, it was constitutional for the Chief Justice to have just designated divisions of the High Court for administrative purposes, and not really to say that the Fast Track High Court have been given less of the jurisdiction meant for the High Court, so to speak. So the expanded panel actually reviewed the reverse the decision of the ordinary panel. Of course, if you look at it, an issue also came up as to whether the Attorney General could represent the Chief Justice. Just as recently, the Speaker of Parliament too, when his mother came before Supreme Court, I know the Speaker of Parliament had been appointed to represent him, and an issue came up. Yes, you are an arm of government. If you look at Article 88 of the Constitution, the Attorney General is the principal legal advisor and also shall define the state. So why don't you allow the Attorney General to represent? But the Supreme Court agreed that there was nothing wrong for the Attorney General. Of course, Attorney General, if you look at it, Attorney General is set up by Article 88, and Article 88 falls within the chapter on the executive. So there's no dispute. The chapter on the executive, that is the chapter 8. There's no dispute that Attorney General, who is also Minister of Justice, is part of the executive. And if that is so, where the Constitution has also created the judicial to be independent, if the Attorney General is representing the Chief Justice, for that matter, the judicial in any legal proceeding, will that amount to violation of the separation of powers? Well, the Supreme Court disagreed, and the court took the view that, yes, the branches of government are independent, but they do not operate in what? Isolation. So I mean, that is the critical point. And the Supreme Court decisions demonstrate that although separation of powers requires branch to maintain autonomy, it does not preclude coordination or cooperation, particularly in instances where the constitutional framework mandates such cooperation. So that is what we should keep in mind. So don't let us be too rigid or too mechanistic. Let me put it that way. Don't let us be too mechanistic so that as soon as we hear separation of powers, oh, if this is done, then that's a violation of separation of powers principle. No. You must have a more nuanced, flexible understanding of separation of powers. Yes, it requires various arms of government to remain within their sphere, their domain, have their autonomy. At the same time, it is also contemplated that there will be the requisite cooperation, the requisite interdependence, so as to propel the wheels of governance. We also have the Asari against the Attorney General's case. So Asari against the Attorney General, of course, there are a lot of his cases. I'm very much aware of that, but this one we're talking about when he invited the Supreme Court to declare as inconsistent with the Constitution the purported swearing of the Speaker of Parliament as the President. Now, as you notice, if we look at the Constitution, we are told that where the President, if we look at Article 60, clause 8, for example, that whenever the President is absent from Ghana or is for any other reason unable to perform the functions of his office, the vice president shall perform the functions of the president until the president returns or is able to perform his functions, as it were. And then it goes on, clause 10. Clause 11, where the president and the vice president are both unable to perform the function of the president, the Speaker of Parliament shall perform those functions until the president or the vice president is able to perform those functions, or a new president assumes office, as the case may be. Now, so it so happened that the president and his vice were not available in terms of Article 60, clause 1 of the Constitution. So the Speaker of Parliament will be sworn in to assume the role of the president for as long as it will take. Now, Professor Azar Asare, relying on the doctrine of separation of powers, which he perceived was on the Constitution, actually invited the court to say that the action by the executive and the legislature regarding the swearing in of the speaker when the president and vice president are unable to perform their function is affront to the Constitution, and particularly undermines the doctrine of separation of powers. Now, the court will make the point that, yes, the core values of separation of powers exist and underlie the scheme of the Constitution, no doubt about that. There should not be impediment to purposive interpretation of constitutional provisions. So the fact that the Constitution reflects separation of powers concept should not be approached in an inflexible manner. So if you look at the opinion of Justice Kluje, who was part of the panel, he argued, among other things, that yes, there exists provision in the Constitution which negates the doctrine of separation of powers. In other words, in his view, if we look at the Constitution critically, there are provisions which actually undermine or do not respect the doctrine of separation of powers. So simply put, it was his position that the doctrine of separation of powers cannot be basis for which clear provisions of the Constitution and the sovereign will of the people of Ghana will be disregarded. So let us keep that in mind. So the takeaway is that when you are dealing with constitutional matters, you must place premium on the text of the Constitution itself, as it were. So let us keep that in mind. Now, I have shared with you Nana Dr. SKB's Asante's public lecture when we were discussing constitutionalism. So if you look at that lecture, he has what you call the contemporary reflections on separation of powers in Ghana. So please look at that. I've just extracted the news from there for you, but look at the full document that I gave you. Now, I would like us to go back to an important case I mentioned, and that will give us an idea of how constitutional jurisprudence of the US has illuminated our understanding of separation of powers, especially checks and balances. Now, there's a case which we call the Youngstown Sheet and Tool Company against Sawyer. And in that case, we'll be discussing it pretty soon extensively. Justice Jackson observed, among other things, that the purpose of the Constitution, that is the US Constitution, is not to avoid friction between branches, but rather to create it to preserve liberty. So you're just trying to put it nicely that, yes, the Constitution does not provide for separation of powers for the sake of avoiding inter-organs or inter-arm conflicts, like in terms of the arms of government. But more importantly, in his view, to even bring about such inter-organs conflict or friction, which will rather benefit preservation of freedom or liberty of the citizen. So he makes the point that the deliberate design of interactions between the branches aims to establish separateness, but interdependence, autonomy, but reciprocity. And that allows each branch to monitor and check others and prevent concentration of power. So if you look at the US Constitution, for example, this is the model of the checks and balances over there. The legislative checks on the executive. So as you know, the US, they have what we call the bicameral legislature. They have like the upper chamber and then the lower chamber. The Senate and then the House of Representatives. And the two combined, we call that Congress. So the Congress holds the power to override presidential veto and also control budget allocation. In a extreme case, it can even impeach or remove a sitting president. And we saw this during President Trump's and also during President Biden's reign. Not only that, even when it comes to appointment, if we look at the US now, we have President-elect Trump is nominating people who will be appointed as cabinet ministers and all that. They will need to go what they call the congressional hearing for approval. The executive also checks on the legislature. So the president can exercise a veto over legislation, or he can require Congress to reconsider its actions, or that Congress cannot go ahead unless maybe they want to have a supermajority to override the presidential veto. So these are all some of the checks and balances. Of course, judicial review, as we know, originally the US Supreme Court did not have an explicit provision on the power of judicial review, that is, whether it can subject laws of parliament and also executive actions to constitutional review. But in the case of Marbury and Madison, as you've read, and if at this stage you have my constitutional law class and you haven't read Marbury and Madison, then you are not doing well. You need to go and read it. Our Chief Justice Marshall, in a very creative and beautiful way, will assume or assert the power of judicial review. Of course, I've talked about the appointment confirmation that the Senate has the power to actually confirm or reject presidential appointments to the judiciary and also the executive department. So you see some checks and balances. So I said we'll be discussing the case of Youngstown Sheet and Tube Company against Sawyer. And that case arose during the Korean War. And the then President Harry Truman attempted to seize control of the nation's steel mills because the workers, those who were working in the steel mills, the factories which makes the steel, and these are needed for military-related production. They attempted to go on industrial action, and if they had done, it would have hampered or undermined the war effort. Now, how did he decide to seize? He will invoke, special executive powers. So let's look at the facts in detail. So this was April 1952. There was a labor dispute in the steel industry. And the dispute culminated in the threat of a nationwide strike. And this strike, the president of the view, would actually disrupt steel production, which was essential for the role the US was playing in the Korean War. There is a law called the Taft-Hartley Act, and that law provides a statutory framework for managing or handling labor disputes. Now, that law was not used by the president. The president did not invoke that law. The president issued an executive order directing the Secretary of Commerce, Charles Sawyer, to take control of the steel mills. And his argument was that he was acting in the interest of what? National security. So maybe if you like equivalent of declaration of state of emergency under our constitution, as it were. Now the steel companies led by Youngstown Sheet and Tube Co. filed a suit claiming that the president had exceeded its authority. So the key issue which had to be resolved was whether the president had the constitutional authority to seize and operate the steel mills without explicit authorization from Congress. The US Supreme Court, in a split decision 6-3, held that President Truman's seizure of the steel mills was constitutional or unconstitutional. And it held that the president did not have the power to unilaterally seize private property without legislative authorization, even in times of perceived emergency. The majority, led by Justice Hugo Black, or Justice Black for short, emphasized that the power of the president must stem either from an act of Congress or directly from the Constitution. And in his view, Since no statutes explicitly granted the president this authority, and since no provision of the US Constitution confers such unilateral power in this context, President Truman's action was found to be invalid. So Justice Black, in his own words, will say this, quote, "The president's power, if any, to issue the order must stem either from an act of Congress or the Constitution itself." So where there is no such basis, either from the Constitution or from an act of Parliament, of Congress, then what it means is that the president was doing something which was not founded on law. Now, Justice Jackson, in his concurring opinion, introduced what we call the tripartite framework for assessing presidential power. And that also gives an important teaching on separation of powers. That one, when the president acts with express or implied authorization from Congress, his authority is at its maximum, as he acts with both the power of his office and Congress backing. Then two, when the president acts in absence of either a grant or denial of authority, there is a zone of twilight in which the president and the Congress may have concurrent authority, or in which its distribution is uncertain. Then the third scenario, when the president acts contrary to the express or implied will of Congress, his power is at its lowest ebb, as he can rely only on his own constitutional powers, minus any congressional authority over the matter. So having given this tripartite framework of the various modes in which presidential power can be properly exercised, Justice Jackson will make the point that in the instant case, President Truman's action fell into the third category, meaning that he was relying on constitutional powers minus any congressional authority over the matter. And for that matter, his power was at its lowest ebb. He had acted against the implied will of Congress, as Congress had previously considered and rejected the measure to authorize such seizures. Then we also have another judge who dissented, but it's not really interesting now. Now, I am interested in contrasting the opinion of Justice Black and Justice Jackson on the doctrine of separation of powers. And many years, as a student of constitutional law at the University of Ghana, it used to be an interesting examination area for our Professor Kumado. Now, Justice Blacks provides what we call the strict separation of powers approach. And in his lead opinion for the majority, he advocated for a rigid interpretation of separation of powers. Justice Black argued that the president's power must either come explicitly from the Constitution or be authorized by Congress. And in his view, any encroachment by one branch of government on the powers of another is constitutionally impermissible, as it disrupts clear structure of government outlined in the Constitution. So this is how he wrote, as we have quoted before. So the president's power, if any, to issue the order must stem either from an act of Congress or from the Constitution itself. So this way of understanding as Justice Black advanced underscores that the executive power is not a flexible or open-ended mandate, but a limited and defined authority, particularly in relation to domestic affairs. So for Justice Black, the Constitution clearly delineates the powers of each branch to prevent any form of tyranny. So if Congress had intended for the president to have the power of seizure of the industry, it will have explicitly legislated as much, particularly since Congress had considered and rejected such a measure. So if you read his judgment further, you notice that Justice Black was advocating that the branches of government have distinct and non-overlapping rules, with very limited exceptions. And as we have said, this is a very rigid or strict approach to separation of powers. And I also have Justice Jackson, who provided pragmatic or flexible approach. And as we noted, he outlined his influential three-tiered framework. And Justice Jackson recognized that while there is constitutional separation between branches, the reality of governance may sometimes require overlapping or concurrent powers, especially in ambiguous or unforeseen circumstances. So his tripartite framework we saw is category 1. When the president acts with explicit or implied consent of Congress, its authority as its strongest. So I would like us to apply these two views to our own constitutional experience in Ghana. So Justice Black's approach to separation of powers and Justice Jackson's approach. So category 2, when the president acts in an area where Congress is silent, there is a zone of toil, as we have said, where presidential authority depends on the circumstances and historical practice. And then category 3, when the president acts against express or implied will of Congress, his authority is at its lowest ebb, and his actions are constitutionally questionable unless rooted solely in his constitutional powers. So if we look at it by and large, Justice Jackson's approach provides us a more nuanced, detailed understanding of separation of powers, and also the flexible approach. But as you notice, Justice Black is a very formalistic or a very strict advocate of separation of powers. And the way he views separation of powers aligns very much with the originalist view of a rigid separation between branches, where powers of government do not overlap whatsoever. Of course, we have disciples of Justice Blacks in Ghana. If you look at the various discourses or commentary which goes on in various media spaces. But as we have indicated, Justice Jackson, unlike Black, suggests a more flexible, functional approach, which recognizes that the branches sometimes must operate with interdependent or concurrent authority. That is, it is possible in a certain matter for two branches of government to be equally competent in dealing with it. Good. So we'll look at our own experience in Ghana. And I will like you to bring your mind, the things that we've observed from the US model to bear on that of Ghana. So no doubt, if you look at our constitution, checks and balances is an integral part of our constitutional framework. There's no doubt about that. And the checks and balances that we have aims at ensuring that no branch of government can exercise unchecked power. So every branch of government in one way or the other is subject to check. Even the judiciary, which is independent, is subject to check. So let's look at the how checks and balances reflects in our constitution. So we have judicial review of executive and legislative actions, and you're very familiar with that. So if we look at the Article 2 of the Constitution, we are told that the Constitution is the supreme law, and all laws, all actions, all steps, measures, whatever, should be in conformity to the Constitution. And where anybody suspects that any law, any action, omission, or commission is in violation of the Constitution, the person is encouraged to go to Supreme Court and see declaration to that effect. We saw the case of the 31st December case. Then we also have legislative oversight of the executive. The executive will present budget proposal. Parliament will have to approve or reject or modify it as it were. When appointments are made, Parliament will have to approve. The Parliament also has the power to investigate executive actions. They set up committees, they have permanent committees, they have ad hoc committees. And the committees mirrors the various portfolios and various centers of governance in the country. And the various committees can hold inquiries regarding anything. So that is another way by which the Parliament exercises oversight over the executive. Of course, when it comes to public spending, the Constitution will say that it's only the executive can introduce a bill which has financial burden for the state, but it's ultimately Parliament which will have to approve or reject. Yes, so if you look at the Article 178 of the Constitution, for example, the executive cannot withdraw money from consolidated fund without parliamentary approval. And this enables Parliament to exercise oversight or checks and balances over executive spending of public purse. As I've said, we have like various parliamentary committees. You have the Public Accounts Committee, for example, which has the power to investigate public spending and executive decisions. And that also provide another layer of oversight. All public institutions at certain times will have to appear before the PAC, the Public Accounts Committee, to answer questions. Now, the president also has a role in judicial appointments. Yes, the judiciary is independent, but the president holds the constitutional power to appoint judges to the Supreme Court and other superior courts of judicature, subject to approval of the Council of State. So one would say that will allow the executive to influence judicial appointments while still requiring a degree of external oversight. So it's not only the president which will play a role. We have the Judicial Council, we have the Council of State, and we have the Parliament, as it were. So the Council of States also has advisory role. So if you look at the Article 89 of the Constitution, when it comes to judicial appointment, is they advise the president. If you look at the Supreme Court decisions, that the president cannot ignore going to the Council of State, but the Council of State, the Judicial Council, all of them are supposed to advise. So the advice must be given, but it's not mandatory for the advice to be taken. But if the advice is not sought for, then something irregular has taken place. Then again, when it comes to international treaties, the Parliament exercises power of approval. So if you look at Article 75 of the Constitution, for example, the president has the power to enter into international agreements, but such treaties and agreements require ratification by Parliament. Therefore, the provision Article 75 can be said to also serve as a check on the executive authority in foreign affairs, particularly so to ensure that any international commitments is in alignment with Ghana's legislative and policy priorities. So that is very important. Yes, and when it comes to impeachment and removal mechanism, that is also another way by which some checks and balances what is exercised. So if you look at Article 69 of the Constitution, for example, that is a framework for removal of presidents. So Parliament can initiate impeachment proceedings against the president if there's evidence of misconduct, abuse of office, or other serious violation. So the fact that the legislature can impeach the head of the executive is also important mechanism of checks and balances. And not only that, the judiciary is also involved in the impeachment. The Chief Justice and other judges of the Supreme Court will play a role in the outcome of impeachment proceedings. And that demonstrates another collaborative nature of checks and balances. Because when it comes to even impeachment of, let's say, the executive, it's not just only the legislature, the judiciary is also involved. So checks and balances, we'll say, is about mutual accountability. But there are challenges. And as we keep saying that some of these concepts, checks and balances or separation of powers, it's not an event. It is a process in the sense that we keep evolving and you keep deepening our understanding and appreciation of them and how it reflects in our body politics. But of course, in terms of challenges, there's a potential for gridlock, as we have seen in our own even backyard. Excessive conflict or partisanship among the branches can lead to governmental gridlock. And now we are seeing it. Parliament is supposed to be in session to get certain agreements, budgets, certain appointments approved. But because the parties in Parliament, the New Patriotic Party, National Democratic Congress, they have assumed, entrenched, if you like, positions which reflects their party's preferences. Parliament is not able to be in session for quite some time, and this has brought about a stalemate in governance, because there are certain matters which cannot go on without Parliament working, as it were. Of course, there's also this a problem of a judicial overreach, and if you look at how the judiciary is appointed, for example, there's a perception that the executive has control over the judiciary. But if you interrogate the real workings of the judiciary, you notice that that perception is not well-founded. Again, the power of the judiciary to do judicial review, while it's essential, must be exercised with restraint in order to avoid perception of overreach or too much interference in executive and legislative affairs. So just like what we witness regarding Afenyo and Speaker of Parliament, and how proceedings are going on in Parliament, and at the same time, process had been filed in the court regarding ongoing proceedings. So those are some of the potential challenges. There's also limited resource for legislative oversight. I mean, the thing to do with money. Parliament's ability to provide effective oversight can be constrained by limited financial and human resources. You must have MPs who have good research support, who have good administrative support to help them to review documents, provide summaries, and build their competencies to be able to interrogate issues when they have to engage various public departments or offices. Yeah, but despite these challenges, system of checks and balances in Ghana has proven resilient and adaptable. As I said, it's still evolving. We are not there yet, but we will get there ultimately. Society is not static. Society is ever evolving. And society is evolving. Our understanding of these constitutional theories or concepts will also evolve. Our practices of them will also evolve. Good. So I will take one or two questions before I draw the curtain down. So maybe before we go, there's a question I think I should let to take and think about, which is this. A strict separation of powers desirable or feasible in the Ghanaian context? Or should a system of interdependent function be pursued? Are there other frameworks that might better serve Ghana's democratic stability and governance needs? Or could the hybrid model, emphasizing functional but flexible boundaries, enhance governance? So these are the things I want you to think about. I'll send the notes to you. Yes, so if there are any questions, I will take them. Otherwise, we'll draw the curtain down.